So although I currently practice as a member of the Paris Bar, now based in London, and my home country is Scotland, most of the cases I've worked on over the years have had connections to either African or Middle Eastern countries. And I'd like to start by going back to when I began work as a trainee lawyer in Scotland, not just to state the obvious about how much technology has changed, but also really to remind us about some of the important lessons in dealing with cases like construction cases when you don't actually have any technology. That's, of course, very hard to imagine for construction cases these days. So please bear with me for a few moments while we travel back in time. Now, one of my closest friends started her legal traineeship on the same day as I did, Monday, the 1st of August, 1983. Her career was in a small firm doing family law, and she retired earlier this year. How she did her work did not change much over the years. She always dictated her court documents, and she had secretarial support to have them typed up. The biggest change for her was having to do online court hearings when the COVID-19 pandemic kicked in. Things could not be more different for me. I also started my career in a small office, handling a lot of court work, mostly for claimants who had been injured at work in Glasgow's shipyards. Mobile phones had not been invented, and in fact, the senior partners in my firm at the time did not even know how to use the phone on the desk. Court documents were also dictated and handed over to the typing pool, who still worked on old-fashioned typewriters. After my traineeship, I left for Paris, determined to find some kind of legal job, what I did not know. And quite by chance, I was offered a position in a boutique firm working on several large construction arbitrations. And that's how I got started in the world of international arbitration and in the construction sector. And at that point, still no mobile phones, still no computers. I spent 3 years in a conference room with a team of engineers going through the fairly painful experience of hand drafting pleadings for construction cases arising out of FIDIC contracts. So the first time I was faced with what we might today recognize as technology was in 1993, when I arrived at a new job in a large Paris law firm to find a massive computer on my desk. You remember how computers used to look, right? And a mobile phone the size of a large brick. And of course, the iconic BlackBerry came sometime after that. And today, of course, I can't imagine functioning without the latest technology. Technology was again key in my final role in Paris before I moved back to the UK, which was as managing partner for an Egyptian headquartered arbitration boutique. Again, most of my cases were construction focused. For its size, the firm had a very sophisticated IT system and access to excellent technology for managing cases. The system was, however, tested when we came into the office on the 25th of January 2011. We could not understand why our intranet with Cairo was down, but we soon learned that the Egyptian revolution had broken out. So what have I learned from having worked in the no technology era that remains pertinent to working on construction cases today? I want to mention 3 things. First, I think the most important point is that we should not lose sight of the fact that technology is not always available to all, meaning that if one party has access to technology and the other does not, they may no longer be on an equal footing. The fundamental principle of equality of treatment is at risk, and the differences between them could prejudice due process. There are good reasons why technology is sometimes not used, Access may simply not be possible, for example, in a country in conflict or in remote places which have no or poor internet access. This is certainly an issue in the remote islands in my home country of Scotland. And access to technology may not be reliable. For example, I'm working with a client in South Africa just now, and she has an email footer setting out the load shedding schedule for the week. In other words, when the electricity is going to be available, and we work according to her schedule. So we're not really used to this in the UK, but given the current energy supply issues, this winter may be very different. Second, another lesson I think to be kept in mind from times when less technology was used is the issue of human contact. Dealing with people remotely has been eased dramatically with technology, especially since the pandemic, whether this be through Teams or Zoom meetings with clients, case management conferences, or evidential hearings. That said, we should not lose sight of the need for, or at least the benefit of, human contact. I think that preparing a case as counsel, especially a complex construction case, is very difficult if you have never met your client or any of the witnesses or any experts. You'll always learn things face to face that you would not in an online setting. You have an opportunity to size up witnesses. You will probably ask questions that you may not otherwise have asked. However, I do think that online hearings are ideal for many cases, and they're certainly the way forward, so there is a balance to be struck. The third and last point that I want to make about little or no technology, well, one of the advantages of working with paper, if there are any, was that it forced you not to make very many mistakes. Otherwise, everything had to be started again. There was no easy cut and paste. It forced you to really focus your case, and only essential evidence was filed with the court or tribunal. You didn't want to be carrying or transporting too many files, so you made an effort to prune things down. With technology may come a temptation to throw in the kitchen sink, in other words, to include absolutely everything, whether necessary or not. And this is not a good thing either from a time or cost point of view. So I'm going to move away from the past now, you'll be pleased to hear, and I want to move on to address what is really special about construction cases. I'm not going to completely forget the past, but moving to today and the future, and looking at how we're using technology in the way we run construction disputes, even if only very few construction disputes are entirely online at present. I'm also going to focus on international arbitration, but I will say a few words about the courts and mediation later on. We know, of course, that construction arbitrations form a significant part of the caseloads of various international arbitration institutions, with the ICC having by far the greatest number. Now, I'm just going to try to share my screen at this point to show some slides. The slides are not really talking points, they're more some resources that you're probably familiar with. You might find some of them useful, so bear with me, please, while I share my screen. Okay. Right, can somebody give me a thumbs up to see if you can see my slide presentation? Thank you. And I'm just going to try and remove all the little bits on the side so that we can see these properly. Bear with me a second. Okay, right, that's a bit better. So I was mentioning the statistics of some institutions, and this is quite a helpful report that you may have seen. It's a report by Jus Mundi on construction arbitrations, which was published in October of last year. And it looked at commercial cases. It went way back actually to 1937 and looked at cases up until 2021. And it noted the various local and international arbitration institutions being used by parties. And of note is that there were a significant number of ad hoc arbitrations in the data, especially in recent years, involving African entities from Rwanda, Tunisia, Tanzania, South Africa, Nigeria, Kenya, and some others. So I seem to have jumped to the next slide without meaning to. Okay, so a lot of what I'm going to say applies to a wide range of cases, and I'm going to try to highlight what I think is special about construction cases. First of all, the level of risks to which construction projects are exposed tends to distinguish construction disputes from many other types of disputes, and it makes disputes more likely. Obviously, there's a huge range of risks, varying from climate risks, commercial risks, such as fluctuations in prices of materials that we're seeing lots of at the moment, or defects issues arising from new technologies, for example, for renewable and cleaner energy projects, legal risks, such as changes in law, and political risks, including state actions. As far as state actions are concerned, there is an increasing number of investor-state arbitrations in the construction arena, in which foreign contractors and investors are claiming relief for losses they incur as a result of these actions, frequently on the basis of protections afforded to them under bilateral and other investment treaties. Another factor which distinguishes construction projects is the number and variety of parties playing different roles that may be involved in projects. So as well as employer and contractor, there may be subcontractors, engineers, and other specialists, project managers, funders, suppliers, etc. Multiple claims and parties are obviously commonplace in construction disputes. The use of standard form contracts, such as the FEDIC suite of contracts, is frequent and is also fairly unique to the construction sector. And of course, construction cases tend to deal with some legal issues that are peculiar to the sector, for example, relating to statutory warranties and limitations, perhaps direct claims by subcontractors against employers, legislation on supply chain requirements, construction concepts such as critical paths and global claims. And of course, these types of disputes also raise very complex technical issues, frequently related to assessing delay and disruption damages. Project deadlines are another distinguishing feature, with the significant investment involved up front, and the fact that projects don't make money until they're completed. Construction projects are obviously time sensitive. And of course, the amounts involved can be very significant. So these distinguishing features of construction cases mean that they need first-class case management by both counsel and tribunals, especially as relates to document and evidence management, expert evidence, the analysis of delay and disruption, and quantification of damages. And this is where technology and online options really come into play and contribute significantly to the efficient and effective running of cases. Many of these issues were explored, and I'm just going to go to the next slide now, in the Queen Mary University Pinsent Mason's International Arbitration Survey about driving efficiency in international construction disputes. Of course, this report was pre-pandemic. Respondents, in any event, said that there was a significant role for innovative technology solutions to play in enhancing the efficiency of the arbitration process. Now, because of the heavy nature of construction cases, whilst the respondents to the survey thought that technical automation, in other words, totally removing human involvement, whilst they thought that that was part of managing large volumes of evidence sufficiently, they did show some resistance to automating the entire decision-making process. What I'd like to do next is really take a run through the various steps in the arbitration process and focus on areas where construction cases need special attention and may benefit from technology solutions. Can I just add here, if there is anyone here today who's not very familiar with arbitration, I learned last week at the ICA conference in Edinburgh of a fantastic new tool for those working in the arbitration sector. I'm just showing it on the slide just now. The Swiss Arbitration Centre has produced a toolbox which takes you through the whole arbitration process. So it's a great reference for people new to the sector and also for very experienced practitioners and arbitrators. It contains several very useful templates. So what I'm showing you now is just a screenshot to bring it to your attention if you're not already familiar with it. The print is probably too small to read properly on the slide, so you would need to go online and play around with the various sections to get a flavour of it, but I can highly recommend it. So the arbitral process, just before we go through that, I want to say a word first of all about dispute resolution mechanisms in contracts. First of all, these of course could be the subject of an entire seminar, so we don't have time to go into them here in any detail. But what I would like to say from the perspective of how construction disputes are handled and how technology may be deployed is that the choice of arbitral institution needs careful consideration. It's probably true to say that most of the rules of the main international arbitral institutions contain broadly similar provisions, allowing for such things as expedited proceedings, the appointment of emergency arbitrators, the granting of interim measures, consolidating proceedings and joining parties, all of which are important in a construction context. However, it is worth carrying out a careful review of any rules that you are thinking of signing up to. Assuming now that an arbitration is commencing, at the outset of a construction case, technology, of course, is key to the selection of arbitrators. And of course, the arbitration process affords you the opportunity to choose arbitrators with experience in the sector, as well as taking into account a potential arbitrator's experience of construction issues. In construction cases, it's particularly important, I think, for tribunal members to have strong case management skills and to really know how an international construction arbitration works from A to Z. And of course, arbitrators dealing with construction cases should also have good skills in relation to the technology that will be used during the dispute. So arbitrators have been appointed, the case is underway, and we have the first case management conference. Obviously a key step in the procedure, and the tribunal, as we know, will produce an agenda of items to be discussed, which will form the basis for procedural order number 1 and the procedural timetable. Some agenda items are especially critical in construction disputes and how technology is deployed in them, and that's what I would like to address now. A moment ago, I mentioned the institutional rules that may apply. And of course, there may be other rules, protocols, or roadmaps that the parties wish to adhere to or use as guidance. And it's important at the case management conference stage to address the topics that these types of guidelines may cover. So the first one I'd like to mention concerns protection of personal data, which is an item that should certainly be addressed at the outset of a case. And in this regard, you'll see on this slide the ICA-IBA roadmap to data protection. And that was officially launched at the ICA conference in Edinburgh last week. I have to say that I've not had time to fully digest this yet. It's a complex and important booklet, or even book, running to 170 pages. Its goal is to enable participants in arbitration to identify and address data protection concerns that may arise in arbitrations. So, as well as describing the main data protection principles that potentially apply to international arbitrations, the roadmap includes practical guidance in the form of various annexes. There is a set of data protection practice tips, a checklist if you're using an online case management platform, and sample provisions for data protection directions by tribunals. So, for example, there are draft directions about what steps must be taken if there is a data breach. Now, the related but distinct issue of information security, and particularly cyber security, should also be discussed at the start of the case. And here is the 2022 edition of the ICA New York City Bar and CPR protocol that you may be familiar with on cyber security. This was also launched at ICA last week and provides very valuable guidance. In fact, it's an update to the 2020 protocol, and it aims to provide a framework for reasonable information security measures in arbitrations. And it also aims to generally increase awareness of information security in international arbitrations. As well as a set of principles, the protocol includes useful schedules. So you have a baseline security measures checklist, sample information security measures, and sample language addressing information security. Personally, I think there should be greater collaboration between counsel on this subject and more sharing of experiences, whether good or bad, among practitioners. So the directions made by tribunals will typically address points such as the use of shared sites or cloud platforms, encryption, password protection, etc. And there may be other rules and guidance that the parties wish to adhere to. The most common is probably the IBA evidence rules. And as I'm sure you know, these are designed to be used in a wide variety of jurisdictions alongside whatever applicable institutional or ad hoc rules apply in a case. And essentially, these are a resource for how evidence may be taken in international arbitration in a fair, efficient, and economical way. Now, of particular interest for international construction cases is that they address remote hearings. They provide that the arbitral tribunal must consult with the parties with a view to establishing a remote hearing protocol so that remote hearings are conducted efficiently, fairly, and as far as possible without any unintended interruptions. Suggestions for what the protocol may address include, among other things, the technology to be used, advanced testing of the technology, training the participants in the arbitration in the use of the technology, how documents may be placed before a witness or the arbitral tribunal, and measures to ensure that witnesses giving oral testimony are not improperly influenced or distracted. Now, another very important protocol with which you will be familiar is the African Arbitration Academy's protocol on virtual hearings, also 2020. And I find this very innovative for a number of reasons, including that it was published only a short way into the pandemic. It underscores that no other guidance notes on virtual hearings are custom-made for Africa, and it includes an annex setting out minimum cybersecurity standards and measures. Under the protocol, the parties and the tribunal must have at least one backup internet service provider and an alternative virtual platform for holding a hearing. In addition, and just coming back to what I was saying at the start about access to technology, the protocol suggests that where parties do not have the necessary technology, they may solicit the arbitral institutions or other centres in Africa that can offer their venues and technology services. Now, of course, there are multiple other protocols for virtual hearings. I've just briefly mentioned some of them on this slide. We could spend days going through them all if we had more time. Now, some other protocols that are not necessarily to do with virtual hearings that I just want to mention briefly, you'll be familiar with the green protocols available through the Campaign for Greener Arbitration. And I've put one of these on this slide, which is the green protocol for arbitral proceedings. There are various green protocols. So for example, there's one for arbitrators, there's one for hearing venues, etc. So this one, the green protocol for arbitral proceedings, includes a procedural order which provides language that tribunals can use to implement sustainability measures in the conduct of the arbitration. I think the protocols represent an important advancement for all kinds of arbitration cases, and I would suggest especially heavy-duty construction cases where sustainability measures not only reduce the environmental impact of the proceedings, but also make for more efficient and streamlined proceedings. So we're still on the case management conference, and inevitably it will include discussion about how written submissions and documentary evidence will be handled, since generally construction disputes generate quite a volume of documents. For the submissions, written submissions themselves, the so-called Scott schedules are often used in construction disputes, and these originated in the Technology and Construction Court in England and Wales. So rather than having to jump backwards and forwards between the parties' separate written submissions on particular issues, Scott schedules can be used to set out the competing claims in a single document, which is much more user-friendly. So, for example, you can use them to compare competing valuations or delay claims and so on. And they also help the parties focus their claims and narrow the issues. Typically, in addition to written submissions, there will be further documents supplementing the submissions, such as lists of key personnel involved in projects, chronologies, of which I'm a big fan, and possibly a glossary. And if these can be agreed between the parties, then so much the better. The tribunal will agree with the parties all the practical requirements of submissions and documentary evidence. So things like normally full text searchable format, everything hyperlinked to witness statements, expert reports, exhibits, and legal authorities, and of course, following an agreed naming and numbering system. Document production, of course, is another area in construction arbitration, another key area in construction arbitrations. And generally conducted electronically, frequently tracked by using a Redfern schedule in which, as you know, various columns identify the documents that are requested, set out the reasons why a party is seeking them, and any objections to their production, and finally the tribunal's decision. The tribunal at an early stage will also discuss the procedure where parties wish to adduce evidence from fact witnesses in support of their allegations. And it will usually set out in procedural order number 1 what witness statements must contain. In England and Wales, the court practice for what witness statements must contain was tightened up last year. The courts had noted that witness statements were often far too long. They set out a lot of unnecessary details of documents and even contained arguments, but they did not give the court the best evidence of the witness's true recollection of factual matters. And in fact, the lawyers were having far too big an input into the statements. New rules were therefore introduced to streamline how witness evidence is handled, and this also helps speed things up. It might be that some of the benefits of those rules will eventually filter through to international arbitrations. Now, the London branch of the Chartered Institute of Arbitrators is holding its next construction event on the topic of fact witness evidence in international construction disputes in conjunction with King's College London. And that's going to take place probably in February of next year. So if you're interested, look out for this event on London Arbitrators event page. We're hopefully going to make it a hybrid event to allow colleagues from outside London to attend if it is of interest. Now, of course, the tribunal will also want to know at the start of the case whether the parties will be putting forward any expert witnesses to address matters such as programming, planning, etc. And preferably, the tribunal will want the parties to agree on the issues for which expert evidence is required. And again, the tribunal will set out in a procedural order what the expert's report must contain. As far as expert evidence is concerned, the Society of Construction Law's Delay and Disruption Protocol, I find, is a very useful document which provides guidance when dealing with delay and disruption matters. So there will likely be further case management conferences, and certainly one before the hearing. But at a pretty early stage, the tribunal will nevertheless discuss the hearing with the parties. And in consultation with them, the tribunal will decide the logistics, which parts of the process will be conducted remotely, which will be in person. The tribunal will also set out the procedure for examining witnesses at the hearing. If witnesses are giving evidence remotely from home, for example, there may need to be special directions or a protocol to specify things like which platform will be used, to guide witnesses through what is expected, with instructions on aspects as how to set up the room, how documents are to be accessed and referred to, and what to do if the technology fails. So a strong tribunal chair will be necessary to give directions to the witness during the hearing. Coming lastly to the procedural timetable, in many construction arbitrations, it may not be possible to put in place a timetable which will respect the time allocated under certain institutional rules for an award to be rendered. So, for example, a 6-month time limit under the ICC rules. But the parties and tribunals should not lose sight of these deadlines, as they may have to follow specific procedures to have them extended. So I want to come on just to mention case preparation and advocacy once the case is underway and once the initial case management conference has been completed. As far as case preparation and management of the hearing itself are concerned, there are all kinds of materials available online, particularly, as mentioned, guidance on preparing for virtual hearings. One important area, especially in construction disputes, is how to better focus on the main issues and present them to a tribunal in the most effective way in a virtual setting. And I really always think that a first step as regards focus is to get in touch with the opposing counsel to see what can be agreed, what issues are undisputed, are there joint presentations that will help the tribunal, agreed technologies, that kind of thing. Depending on the case, a lot can be agreed even in advance of Procedural Order 1 and certainly in advance of a hearing. And all of this will make counsels and the tribunal's job easier and save on time and cost. Obviously, one of the biggest challenges in construction cases is how to manage voluminous documents. And it should be fairly straightforward to put in place a simple system to populate a common hearing bundle from the start of a case. Documents which parties and the tribunal would normally want to have available at the hearing, including procedural orders, pleadings, exhibits, witness statements, experts' reports, and key procedural correspondence, can be added on an ongoing basis. Then, at the relevant time before a hearing, counsel can add items such as agreed or not agreed, chronological or key document bundles, and any individual party presentations. Now, this may seem glaringly obvious, but the extent to which a single hearing can involve multiple methods of document management and very little effort to streamline hearing documents is quite remarkable. Now, there is, of course, various software available to make document and exhibit management easier, such as Exhibit Manager. And also, to my mind, the skills of a good paralegal are highly valuable, and I've been helped out by some really excellent paralegals many times. If you are in the unenviable position of having to create an electronic bundle on your own, help is at hand in the form of a marvelous video by two barristers at St. Philip's Chambers, which I'm showing on the slide. And they talk you through exactly how to create and manipulate electronic bundles if you have to do this yourself. So the whole technology aspects of the hearing is really a key area where the types of protocols that will be put in place further to discussions between the parties and tribunals is developing quite considerably. More detailed and more frequent pre-hearing case management meetings, I think, now are held with tribunals with IT experts present. Additional meetings for testing all the issues that are likely to arise during the hearing take place, and a myriad of issues such as the data protection and cybersecurity, which I already mentioned, and a plan B for things when things go wrong are often planned into a technology protocol. On the question of whether advocacy is really being conducted differently in construction cases as a result of the pandemic, of course, we've been given an opportunity to review what is really required in terms of advocacy and what adjustments we might make. So, for example, it's more critical than ever to have user-friendly, preferably agreed and streamlined electronic hearing bundles. Tribunals might ask for skeleton arguments. I think this is increasingly the case, and these prove especially useful in a virtual hearing context and sometimes take the place of openings. Traditional openings now tend to be shorter, possibly dispensed with or dealt with in writing beforehand. we should go back to the basics of cross-examination and think carefully about who we really need to cross-examine, why, and to what extent. Oral closings are frequently replaced by written post-hearing briefs, and more hearings probably take place in stages rather than all at once. So I want to mention just briefly other ADR methods for construction disputes. The sector, as we know, uses a number of dispute resolution processes ranging from litigation, adjudication, which is mandated by statute in a number of countries, arbitration, mediation, or dispute boards. And it's probably true to say that the pandemic has generated a growing interest in alternative, or now more often referred to as other appropriate methods of dispute resolution outside arbitration and litigation, especially for construction disputes. And I want to take a very brief look at mediation. Of course, construction contracts sometimes provide for mediation as a prerequisite to arbitration or litigation. And parties may also decide to use mediation at any time in the life of a dispute. Some of the main advantages of mediation, as you all know, are speed, cost, preserving business relations, the ability to come up with solutions that could not be ordered by a court or tribunal, and critically, I think, maintaining control of the outcome of a dispute, which is outside your control as soon as you start a court action or an arbitration. Before the pandemic, the vast majority of mediators would have told you that online mediation was not really very satisfactory, but the pandemic has caused views to change. And while some mediations clearly benefit from an in-person connection, especially if they're very complex, long-standing disputes where the parties have adopted very entrenched positions, most mediations can be conducted perfectly satisfactorily online. As with arbitration, there is also a mediator's green pledge, which you can see on the slide, setting out measures that mediators and participants in mediations can adopt to conduct mediations in a sustainable manner. I've signed both the arbitration and mediation pledges and encourage you to do so too if you have not already. In many jurisdictions, parties are encouraged to attempt some form of ADR before engaging in court action or arbitration. This is certainly the case in England and Wales. Court pre-action protocols already provide for and encourage parties to engage in ADR, and it appears that further reforms may compel parties to engage in ADR. This is already underway for small claims in England. In France, for example, any new court action has to explain what attempt has been made already to resolve the dispute amicably. The Technology and Construction Court in England in particular strongly advocates ADR, and that court's guide sets out the court's role in encouraging parties to engage in ADR and requires the court to specifically discuss options with the parties at the first case management conference. Of course, unreasonable refusal to engage in ADR can result in cost sanctions, and there are many, many cases in England on the question of cost sanctions. I also understand that in Nigeria, the High Court laws of Lagos State allow the court to refer parties to mediation. I'm convinced that mediation has a promising future, including for construction disputes, and I think that arbitrators, and it's actually provided in some institutional rules, should remind parties that settlement is always a possibility and take steps to facilitate settlement where appropriate. So before I finish up, how am I doing on time? Another couple of minutes, perhaps. Just quickly, I want to address the future of resolving construction disputes. What do users want? What challenges are faced? And what's the role of the institutions? For the institutions, I want briefly to mention some new rules that were introduced by the Scottish Arbitration Centre at ICA last week. I'm not, of course, suggesting that you want to use these in African disputes, but I wanted to draw your attention to several innovations in the rules. So these introduce a dedicated online platform which will be used for all cases. It's not an option. Participants in the arbitration, when appointing arbitrators, must have regard to the equal representation in arbitration pledge and must have regard to racial equality for arbitration lawyers. And the tribunal is required to have regard to the data protection roadmap and protocol that I mentioned, and also must have regard to the green protocols. So these provisions apply in all types of cases, but there's no doubt that certainly construction cases will benefit from this type of provision. And I also want to mention a couple of reports. I'm just going to jump through these, but they're here for your reference. ICC Commission report on construction arbitrations, another ICC report on technology in international arbitration proceedings, and also the Chartered Institute framework on the use of technology. And very lastly, before I finish, I would like to mention two important surveys about the future of arbitrations, both of which are relevant to construction disputes. The first one is the SOAS University of London survey led by Professor Onyema and sponsored by Broderick, Bozimo and Vincent Masons. And the survey has ingathered the views of African arbitration practitioners about the effects of various events on their practices, the pandemic, climate change, the Africa Continental Free Trade Area, and the increase in infrastructure projects. Relevant to our discussion today, the survey asked respondents about awareness and use of the protocol for virtual hearings in Africa, and it also asked about construction and infrastructure projects. The survey results are due to be unveiled this November at two conferences in Ghana. And the second and last survey is the one that's being carried out at the moment by Vincent Masons with Queen Mary University of London. That is about the future of energy arbitration, but it's relevant to infrastructure, construction of energy infrastructure, for example. So I think it is of interest for anyone who's involved in construction arbitrations. There's a link on the slide if you would like to complete the survey. And if you would like to be interviewed for the survey, please also reach out via the link to Queen Mary University. The survey team is very keen to get the views of African practitioners. So to conclude, I would simply say that we should bear in mind that arbitration is the parties' process, and they should not hesitate to be as creative as possible. I think that construction disputes can really benefit from sensible creativity. Parties should not hesitate to adapt procedures and use technology to meet their specific needs. And whilst the lessons of the past should not be completely forgotten, we should embrace new technologies and make them work for us. In doing so, we will need to perform various balancing acts to find an equilibrium between human contact on the one hand and virtual processes on the other, and a balance between the need to resolve disputes promptly and efficiently whilst respecting due process. So that's it from me. I hope I've not talked for too long, and I'll be very happy to take questions.
Can I ask a question? Or is it a comment?
Yes, I can go ahead.
Yeah. Thank you very much for such detailed education on the use of online arbitration. So it looks like we'll be looking forward to hearing from you again, because you have really dealt with online arbitration. Continuously, we're beginning to see in the construction industry that mediation might be a better fit than arbitration in some aspects of disputes that they're beginning to encounter these days. Arbitration will address a dispute on the basis of facts and law. Sometimes one might need to look back to the causes of this dispute, because there are situations where a dispute occurs that is no fault of either the investor or the professionals. And we're beginning to have more of that. For instance, for big constructions that started before COVID and were caught with COVID, by the time they were getting out of COVID, all sorts had happened, which was not due to the fault. Now, deciding on facts and law might not be necessarily the best way out. Sometimes parties might need to sit down and rewrite their contracts. And the only process that gives them that opportunity is mediation. We're seeing all sorts all over the world, from effects of the war between Russia and Ukraine, Brexit and all that, and increases in fuel prices. Most construction sites are going through a lot right now. For instance, in Nigeria, diesel prices, or the price of diesel, shot through the roof. And there's hardly anything that happens on the construction site that doesn't involve the use of diesel. So the contractors find themselves not being able to deliver at the rate initially contracted, and are having to sit down with the investors. So one way or the other, mediation is going to play a frontal role in resolving of disputes that are in the construction industry. So we look forward to this sort of depth of education on online mediation in dealing with construction disputes. So I'm sure we'll have to invite you again sometime in the future.
Well, that would be wonderful, because I'm a huge believer in mediation.
Yes.
I totally agree with your comments. I mean, so often the disputes may be nothing to do with the law, or and parties really need to sit down and find other sensible solutions.
Yes.
You would even find that even for environmental disputes, when it comes to construction, that you would actually find mediation will be best suited even for environmental disputes, even though the disputes probably arise out of the society, a clash between the society and probably the investor, or even the company who is in that environment.
Yeah, absolutely. I mean, I have an environmental mediation ongoing at the moment, and really mediation is a much better tool for it than arbitration would ever have been, although the parties had an arbitration clause in their contract. I see there are also some, I'm just taking, I hadn't had a chance to look at the chat until now, so I'm just taking a quick look at what's being said. Okay, yes. Yeah, that was your question, Morniki. Do you think online mediation can be carried on along with online arbitration in construction cases? I mean, of course, mediation can be used really at any time. You can find a window in an arbitration for mediation. You can even do it after an arbitration. So I think there's a lot of room for creativity, and I think people really have to. I think it's really important when you're involved in arbitration to keep an eye on things to monitor it for an exit strategy, which might involve a mediation. So absolutely, it can certainly be carried on at the same time. And I see there's the ICODR standards are more of guidelines for both individuals and organizations agreeing protocols. Yeah, okay. And then there's another question, is the backup for virtual hearings and alternative platforms such as Google Meet or an alternative internet provider? I'm not sure that I'm not sure if that question is aimed at asking what an appropriate backup would be.
Who is that question from? Maybe the person can give some clarification.
Hello, can you hear me?
Hi. Yes, hi.
Yes, sorry, you'd mentioned the backup, and I didn't know whether you meant that apart from maybe using Zoom, I should also have an alternative platform such as Google Meet, or you meant that I have to have dual internet connections? And
yeah, I mean, when I read the protocol, I thought it actually meant both, that you had to have some sort of backup for your internet, and then also also some sort of backup in terms of the platform that you would use. So let's say you're on Zoom and it fails, then can you jump onto Teams and do the same thing? That's what I understand when I read the Africa protocol, but others maybe have much more experience of that than I do.
Okay,
thank you very much.
Okay, so I think to answer your question, I think it's a two-way thing. So you could have that backup for a dispute resolution platform, but Zoom or Google Meet are not necessarily ODR platforms. They're meeting applications designed for meetings, not specifically for dispute resolution. But for us in Africa, you find out that sometimes you have to have like 2-3 ISPs, because sometimes one will just stop working right in the middle of your meeting.
Right.
We have low times or out times like that. So it's actually better for you when you start. And once the protocol is agreed to say, well, if for whatever reason I'm off, please hold on a bit and we can regroup with this or with that, or that if one person goes off unexpectedly, because that happens.
Hello.
Hello. So many people even on this line would have might have been bumped off at certain times in the course of this 1 hour. So yes, it's necessary if you're in Africa or in a place where the internet, it's not only in Africa, sometimes even in Brazil, sometimes even in the US. I've been on meetings before and you would hear, oh, well, we got a power outage with all of the storms and all of that. So yes, it's important that you do that. Yeah. Someone has their hands up. Traders' rights, please go ahead.
Yeah, hello, good evening.
Hi.
Hello. Yeah, that's the traders' rights. Yeah, good evening.
Hello.
Hello. I hope network is not disturbing, but let me try and speak up. Good evening.
We can hear you.
Go on, we can hear you.
Okay, I have the floor, right? Okay, I've actually enjoyed the conversation, and I thank you very much because it's quite educative actually. But my side, where I come from, is regarding a group of people that are within our society in Nigeria, Africa in particular. The traders, we operate among the traders. And these traders, some are illiterate, some semi-literate, some are large-scale traders. And having been working amongst them, I come to realize that, in fact, there is actually a need for these people's mediation, arbitration, involvement for them to be enhanced. Even when I go online to try to browse on these issues, it's like there is just not so much that is there available for this group of people in our society that's scattered all over Africa. In Nigeria, we have very big markets, squabbles, misunderstandings between apprentices and their masters. So much troubles. And like the arbitrators and mediators have not really taken time to look into the cases of this sort of people. So I think there is a gap in the arbitration work that has been going on, which actually needs to be filled. Thank you very much.
Yes, thank you very much for that comment. I think that's very interesting, and you're actually making me think of a small dispute resolution provider that we have in Scotland, and it's for kind of, I suppose, smaller claims, but the idea is to reach everyone, and it's completely online. So it's arbitration and mediation, and everything is conducted online. There is no, there are no personal meetings at all. I'm a panel member on that. It's called Squaring Circles, and it sounds as if it might be broadly comparable to what you've described, because it was felt that there was that kind of gap that you've described. So thank you for that.
Thank you, Gillian, for that wonderful presentation. My question is, because these disputes are usually between different countries, when it comes to enforcement, who really enforces this when it comes to arbitration? Because, like, for example, in Africa, we find a lot of these construction companies are not necessarily from the same country. They come from another country. And now when it comes to this arbitration, which rules are going to be used? Is it for the country where the construction is being done, or is it for the country where the construction company is coming from? Who enforces these rules?
Okay, so thank you for that question. The enforcement for international arbitrations is done through the New York Convention. So that's one of the huge advantages of arbitration, because most countries have signed up to the New York Convention. So that is it simplifies and makes easier enforcement of foreign arbitral awards. And there's a similar convention that has now been started for mediated settlement awards. So that's the Singapore Convention, which is much more recent, but it's the same idea. So that's for enforcing mediated settlement agreements, and there's still some way to go with that, because for the moment, a lot of countries still have to sign up to the Singapore Convention and to ratify it.
Do these construction companies, is it the country that signs to the convention, or is it the particular country that is part of that?
So it will be individual countries who sign up to the convention, and that makes it easier to go to the court of another signatory country to enforce the award.
Thank you so much, Thank you
Yeah,
so
just-
much, Gillian.
Yeah.
Thank you. It has been an educative session. We have exhausted our 1 hour slot. It has been quite educative. We wish we could go on. And like Mr. Adenuga said, we would definitely be having you back. So thank you to everyone that joined us. Thank you for your questions, your comments. It's really contributed to making this session very interactive. We would be ending this now. Thank you so much once again, Gillian. Thank you to everyone that took our time to attend this session. Thank you and do have a lovely day. We would send the recordings via email and the slides. Gillian has so graciously obliged us with her slides. We would send that as well via emails. Thank you everyone once again and do have a lovely day.
Thank you.
Thank you.
Thank you.
Bye.
Bye-bye. Thank you.
Bye-bye, Gillian. Thank you so much.
Thank you, Gillian. Thank you, Odr.